Hello, Leanne, and I am excited to see you today because I know you are in Ottawa, Canada, and I'm sitting here in Toronto, Ontario. And the reason you are there is because you are there to experience a once in a lifetime, possibly more than once in a lifetime, experience watching the justices of the Supreme Court of Canada listen to a family law case and make a determination that will affect thousands, if not hundreds of thousands of women and men on something that is very dear to you. So please tell us, why are you in Ottawa and why did you go to the Supreme Court of Canada?
Yes, it's been a very exciting 2 days. I've been here in Ottawa since yesterday. And the reason I'm here is that the Supreme Court of Canada is hearing a case called the Ahluwalia case. And it's essentially a husband and a wife, both with the same last name. And it's a case out of Brampton. So that's where the original trial was. And it's a significant case and very near and dear to my heart because the issue in the case involves whether or not the Supreme Court of Canada should be creating a new tort for family violence damages. And
what's a tort?
A tort is essentially, it's like a cause of action. So other examples of torts would be assault, battery, intentional infliction of mental distress. And those are torts where in the past, sometimes in cases involving domestic violence, courts have been able to award damages using one of those torts. But essentially, it's been argued that a new tort should be created because of the prevalence of family violence in our society and the amount of it out there and the number of cases that we deal with that involve it. The argument is that it's time for the court to take a proactive step and expand the existing torts to include one for domestic violence. And
so what happened with the Ahluwalia family that has this matter brought all the way up to the Supreme Court of Canada?
So essentially, the Ahluwalia family involves a couple who met in India. They're Punjabi. They met and married in India in 1999, and they came to Canada in the early 2000s. And it was in 2016 that Mr. Ahluwalia actually filed for divorce. The parties had separated by that point. But during the course of the marriage, Mrs. Ahluwalia was constantly abused in various ways by her husband. She was mentally abused, emotionally abused, physically abused, financially abused. Pretty much every type of abuse was inflicted on her during the course of the marriage. And they have 2 children from this marriage. And just to give you an example of how bad the financial abuse was, is that when she left, she fled to India for a period of time. And when she was there, he cut her off from all financial support. So when she was in Brampton and he commenced the court application, she couldn't even afford a lawyer because she had no money. So she represented herself, which is what is, most remarkable about this case. I mean, there was counsel, very esteemed counsel, arguing before the Supreme Court of Canada. But at the initial trial in Brampton, before Justice Manhane, Mrs. Ahluwalia was a self-rep.
And so, if I'm right, the Ahluwalias were of Indian background, and their case was in Brampton, which has a prominent Indian community. Mm-hmm. And is it right that the judge also was of Indian descent?
I believe so, although I'm not 100% certain of that. You might know, I haven't appeared in front of her before. I don't know if you have, Steve.
And so, let me ask you this then. From what you heard today and yesterday argued, is this tort or family violence something that happens to be particularly unique to the Indian community, or is this something that really affects all aspects of life?
No, it's widespread. It really affects any case involving family violence. And the particular focus of the arguments was on what we call intimate partner abuse. So family violence involving, two parties who are in some form of intimate partner relationship. Although there was an intervener, there was numerous interveners at the court for this case. And one of them was from Justice for Children and Youth. And they were actually arguing that the definition should be expanded to include children who are abused as well, whereas the other parties were really focused on the intimate partner abuse. So I'd be surprised if the Supreme Court of Canada goes that far with the definition, given that it wasn't really being argued by the other parties. But it's interesting to note, when this matter went to trial, Mrs. Ahluwalia was awarded $150,000 in damages. So
if I remember correctly, it was $50,000 compensatory, which covers her pain and suffering, yep, much like somebody who maybe breaks an arm or suffers some form of physical injury. Then she was given another $50,000 for aggravated damages because of the cruel nature of what she endured. And then on top of all that, she was also granted punitive damages, mainly to punish the husband. And why don't you tell us what happened to Ms. Ahluwalia when her husband appealed to the Ontario Court of Appeal?
Yeah, so interestingly, the Ontario Court of Appeal did not agree that there should be a new tort created for family violence. The Court of Appeal, and it was Justice Bonotto who wrote the decision, the Court of Appeal's position was that the existing torts, mainly of assault, battery, and intentional infliction of mental distress, that those were sufficient to cover this type of situation. And so the award of the $150,000 in damages was still upheld, and that was never, throughout this case, that hasn't been an issue. But the court felt that the existing tort regime, or the court held, not just felt, that the existing tort regime was sufficient and adequate to deal with family violence, and it was not necessary to expand the definition.
Now, I do know that the Ahluwalia case at the Brampton level before Judge Manhani came out after the introduction of the changes to the Divorce Act in 2021. And it was that legislative change that actually invited and introduced for the first time the phraseology family violence. And in fact, it defined family violence. And there's this whole long list of what constitutes family violence. And it's exactly what you just said. It's all those kinds of behaviors that are more or less despised by society and by the law. And if a spouse treats another spouse in that way, that's called family violence. Mm-hmm. And if I understand correctly, the Divorce Act defined it only in respect of parenting considerations, not to determine whether somebody should get a divorce, not to determine if somebody should get spousal support or child support, and certainly not to determine if somebody should be getting more or less property. And Judge Manhani basically borrowed the definition of family violence from the parenting laws and effectively created a new law using that definition to compensate victims of family violence, which was never intended by the government of Canada.
Yeah, that's exactly what happened. And the Supreme Court, the justices had a lot of questions for both sets of lawyers as to, why for the appellate, Mrs. Ahluwalia, for her lawyers, like, why should the existing torts be expanded? If she got her damages of $150,000 and nobody's saying that wasn't sufficient damages, so she was awarded that. It was recognized that she had been abused, and that was the reason why she was awarded this amount. So why does there need to be a new tort if she can already be properly compensated under the existing tort regime?
Now, being a lawyer for the last 30 plus years, I've been following, like every lawyer does, as a student of law, the cases that come out of the Supreme Court of Canada, from the Carter decision that brought about medical assistance in death legislation, or how about all of those charges over the last 50 years for drug infractions on the subject of cannabis, which ultimately led to the legalization of cannabis? Or how about abortion rights in the Morgenthaler case? Or how about Sunday shopping with respect to the Magder case? Or what about same-sex marriage? But those cases all, once the Supreme Court of Canada finished, fundamentally changed the law in Canada. But this one, at the end of the day, this is not going to affect Mrs. Ahluwalia. She got her $100,000, and it won't affect all the other people that could have previously sued for compensation, just using another phrase called intentional infliction of mental distress. So why would the Supreme Court of Canada even bother with this? Because it doesn't change the law, it just changes the name of the law.
Well, the argument that was made is that, first of all, because family violence is so prevalent, it's got its own unique considerations. And so trying to ground it into one of these other tort headings is problematic, and it doesn't always fit. And it makes it difficult for victims of family violence to navigate that. Because one of the things that was emphasized is that we talk so much today, and the Supreme Court of Canada talks a lot about this as well, access to justice. And we know that 40% of family law litigants are self-represented. And so the argument was made that it's difficult for self-represented people to understand torts and trying to ground it under, what is intentional infliction of mental distress. And it makes access to justice more problematic. And so having a new tort specifically for family violence would make it easier for those who are, representing themselves to apply tort law in order to get damages. And Martha McCarthy, who was counsel for the appellate, Mrs. Ahluwalia, she was one of the counsel along with Julie Hannaford, she said something that really resonated with me. And she said that, we talk so much about access to justice. We don't talk about access to adequate. Because the argument that was being made was that the existing regime is adequate. Adequate was the word used. And her point is, we don't just want adequate, we want better than adequate. And so creating the tort, expanding tort law to include this, would make it more helpful for victims of domestic violence who essentially have a really hard time accessing the justice system to begin with. They've already been in a relationship where there's been a huge power imbalance. They often don't have financial means. They often, their self-esteem and self-confidence has been so denigrated through the abuse in the relationship for them to even step forward and have the courage to leave, let alone commence court proceedings, is hard. So we want the system to be accessible to them, and creating this tort would be helpful for that. And sorry, go ahead.
I was going to ask, with respect to this, if this actually is elevated to the point where represented people with money and have lawyers, people without money have lawyers, if they can, as a result of a failed marriage that involves some version of family violence, which we admit could also involve non-physical contact family violence, emotional, verbal, financial, and so forth, are we not cracking the door open to flooding an already overburdened court system with people adding more issues to their divorce? Because remember, they're still fighting over parenting. They're fighting over child and spousal support and property division. Now we're adding one more thing for them to potentially fight about. And I thought, as a young lawyer, that Canada was a no-fault divorce regime. Are we now just simply bringing fault back in? Because in every failed marriage, people are going to want to point the finger and say, she did something wrong, he did something wrong. And if we're not even talking about physical contact, which we know is criminal, but we're talking about verbal, emotional, financial, are we not just simply going to make every divorce a litigation over bad behavior?
Well, there's going to have to be parameters surrounding, what this tort entails. If the Supreme Court of Canada decides to create this new tort, there'll have to be parameters and boundaries about what it entails, just as there is now with the available tort of intentional infliction of mental distress. And one of the things that was said at the court, yesterday is that floodgates being open is not a reason not to do the right thing. If floodgates open, so be it. But there, in Justice Mandami's decision at the trial, she had, very specific criteria that surrounded what created the tort of family violence. And so I suspect that if the Supreme Court of Canada goes ahead and decides to create this tort, they'll either adopt something like what she had, or there'll be something similar. So it won't be available in every single case, because there's going to be strict parameters about what meets the definition. And it's not going to be generally one isolated incident that, you were called a name by your spouse and that's sufficient to ground it under family violence. It's going to, part of the nature of it is the repetitive nature of it, that it's ongoing over a period of time. And, the coercive control element is a big part of it as well. So if the correct parameters are put in place, it won't open up the floodgates. And the other thing that was argued that kind of touches on what you just said, Steve, as well, is that, in family law, we've really had to move towards trying to settle cases and not encourage, conflict and litigation and trying to resolve things. And would creating this tort also work against that type of approach? But again, if someone's being abused in an intimate partner violence, they should be compensated for that. This idea that treating you can treat your family worse than you treat a stranger. If you assault a stranger and they want to sue you for damages, you'll be successful. So why, if you assault your nearest, dearest spouse, the person you profess love to and married, why should that be treated differently than, assaulting a complete stranger?
It'll be a very curious question to see, because this is one of those cases where whatever the court decides, there will be the right for victims of family violence to seek compensation. The question really is what is it going to be called, and what are the principles governing it, and what are the guidelines, and what language do we use? But either way, this is not about whether people will be able to get an abortion or not, or smoke cannabis or not, or use medical assistance in death or not. Either way, the population of Canada will have the right to sue for compensation if they suffered some language used to describe family violence. Let me move to another topic. I myself have never been to the Supreme Court of Canada to watch a live case. I've visited it, but I've never actually been there. Can you walk us through what it's like? What's the pomp and ceremony like walking into the Supreme Court of Canada and the judges being ushered in by security? Share with us a day in the life at the SCC.
Well, it was an amazing experience. I mean, the building itself, both outside and inside has, definitely it's impressive. And going in and seeing, the justices walk into the courtroom. I thought it would be more grandiose in a way. Like it just, I don't know the proper term for the person who opens the door and they come in. I don't know if it's a registrar or a bailiff or whatever the proper term is. That person just announces.
Is it Harry Potter?
It's definitely not Harry Potter, but okay. He just says the court. And I thought that was interesting. Like I was expecting something a little more, I guess, exciting maybe than that, but that's what's said. And then
do they all walk in one line, or do they come in as like from two ends?
No, they walk in one line with the Chief Justice coming first, Chief Justice Wagner, and they take their seats. And they were all very engaged, so that it was interesting watching their interactions with the lawyers. They asked very good questions, and as a lawyer myself, I know what it's like when you've prepared submissions and you go into court and you've got it all organized exactly how you want to say what you're going to say, but then the judge cuts you off right at the beginning and starts interjecting with questions. And in this case, you have 9 justices, cutting lawyers off and interjecting with questions. And so you could see how, for somebody who didn't know their case inside out, which all of these lawyers did, it could be off-putting or throw you off your game a little bit, the way that they interject. And the other thing that was really interesting is they adhere very strictly to their timeline. So each counsel for Mr. and Mrs. Ahluwalia were given 1 hour for their arguments, and then there's many interveners, and most of them were just given 5 minutes. The Attorney General of Canada and Attorney General of BC were given 15 minutes, and the court generally adheres quite strictly to that. And so there's a couple instances where counsel would ask if they could go a little bit longer. In fact, Ms. McCarthy asked that and was given a little bit more time. And sometimes with the interveners, one of the justices would ask them a question that was causing them to have to go over time. So they had asked for permission before answering the question even. And so I think it's a good thing. It limits what lawyers are going to say. And so from that standpoint, maybe somebody might not feel heard the same way, but I think it's good having these time limits so that people have to really
time limits, and the judges are peppering them with questions. How much of their, for example, 1 hour would they have been able to just freewheel with their own submissions, and how much of that was eaten up with questions and answers?
There was very little freewheeling. A lot of it freewheeling. There was a lot of questions. They had very poignant questions that they asked, and most of it was that. In fact, towards the end, with some of the interveners, they were kind of more just giving their submissions, and the court wasn't really interjecting. But certainly with counsel for both Mr. and Mrs. Ahluwalia, it was the court really interrupting and asking very specific questions.
And as a lawyer sitting there, and you could understand the language and you could understand what might be infused in the questions. So my question to you about the questions that the judges asked the lawyers, could you read into the questions where certain judges were leaning?
I was trying really hard to do that. I thought that I would come out of the court with an idea of which way I thought the court was leaning based on their questions. But I can honestly say I really don't have an idea, because when they were asking questions for Mrs. Ahluwalia's counsel, the questions were really like, well, why? Why do we need to create a new tort? Why isn't the existing tort law all right? Like, she got the damages she wanted, like, why create a new one? But then when they were asking questions to Mr. Ahluwalia's lawyer, the court was saying things like, but isn't family violence a little bit different? Aren't there things about family violence that make it unique from other types of torts that should be taken into consideration? So they were really playing devil's advocate on both sides. My gut feeling or my instinct is that they may rule in favor of creating the new tort. I think the fact that they granted leave for the case, they could have just, the way it works for our listeners is that after it went to the Ontario Court of Appeal, the Supreme Court of Canada has to give leave in order to accept the appeal and to hear the case. And they did grant leave. They obviously thought the issue was of sufficient public importance. And they seem to have, just based on their questions and comments they made, they definitely appreciate that intimate partner abuse is a serious problem in this country, and that the numbers of cases involving it are huge. And that
didn't the Supreme Court of Canada deal with domestic violence in the context of family law in the parenting case of Berendrut? And they identified the fact that family violence is pernicious and a factor to be considered even insofar as parenting issues go, because historically people would say, well, he was a really bad husband, but he still loved his son, or she was a really difficult wife, but she still loved her daughter. And so the Supreme Court of Canada sort of already dealt with family violence as being something important in the past.
That's true. And certainly their comments, today and yesterday left me with no doubt that they appreciate the importance of it as a public issue. They understand the problems behind it. And, one of the issues as well with creating a new tort is it the judges who, this always comes up, should that not be legislated? Should the legislature not be dealing with this if that's what should be done? Like, what should judges be creating law? And, the argument that was made on that is that, sometimes there is judicial created law to keep up with the way society has evolved and changed. And the argument was that this is one of those types of situations. And so, the legislature made the changes to the Divorce Act and some things there that are reflected with respect to the issue of family violence, but that now's the time for the court to also move the law along with the times. Our laws today, even when judges are hearing, it's not based on, the 1800s, although there are some cases that probably have stood up that long, but it evolves as society evolves.
Now, bringing it home, we at Benmor Family Law Group have lots of cases. Really, I don't think I have a case where one spouse doesn't have something negative to say about the other spouse. Now, some people whitewash it, dilute it, and really don't want to even disclose it. And others, in some cases, exaggerate what may have happened. And there's another side that you don't really hear. But when we talk about the outcome of Ahluwalia, whatever it is, how does this change how you, Leanne, are going to be interviewing new clients who come in and say, look, I left my wife, I left my husband, help me. What are you going to do now that you have this tremendous insight and understanding of not just the word Ahluwalia, but really all of the implications of family violence in family law matters and the right to compensation for it? What's this going to do to you and the way you practice law?
Well, certainly it's going to be something that when I'm interviewing a new client, I will be asking questions about the relationship and the nature of the relationship, and analyzing and assessing, was there forms of coercive control? Was there, in Mrs. Ahluwalia's case, he really isolated her, which is an element of coercive control, where she didn't really have any friends. She was isolated. Her family was back in India. So, you look for those sorts of cues. Does somebody control all the money and the finances, and certainly physical abuse is easier sometimes to identify as being abuse, but now that there's so much education and understanding about all of these other forms of abuse, it's something that I think any family law lawyer, when they have a new client, they have a duty to make inquiries about those types of issues so that they can properly assess whether they should be considering bringing, as part of the application, seeking damages, whether it ends up being under a tort of family violence or a tort of intentional infliction of mental distress or emotional distress. But
in the last few years, just from the Ahluwalia case at the trial level in Brampton, there has been a surge of people pleading damages for family violence with whatever language they're using. And it's also been a way, even if they're not ultimately going to get compensation, to demonstrate what they had been living through, and hoping that the negative imagery that is being provided about how they have been victimized by their spouse for many years, how that might bleed into the sympathy of the judge in dealing with the other issues, whether it's parenting or support or property division. So I think the interesting thing about the Ahluwalia case and how much attention it has gotten all the way to the Court of Appeal of Ontario and then all the way to the Supreme Court of Canada, and having all these judges engaged in it and all these interveners, it's brought so much attention to the gravity of the subject of having a spouse hurt a spouse in a domestic relationship, that there's just no escaping it right now. The genie is out of the bottle.
Yeah. No, and I think it can serve as a deterrent potentially for some abusers. I mean, obviously we've had the criminal courts, so somebody can always be charged criminally for offenses of domestic violence, but sometimes for a whole variety of complicated reasons, survivors of domestic violence don't want to have their child's other parent charged as and have it criminalized. So this offers another vehicle for them to gain compensation for what they've been through, but also more importantly to be validated in terms of what their experience has been, and for it to be recognized, and for them to see the other side, in a sense, punished for their actions.
Why don't you give us your final thoughts and wrap it up for us?
Well, I can honestly say the last 2 days have been absolutely an amazing experience. I've seen the Supreme Court of Canada from outside when I've visited Ottawa, but this is the first time I've been inside and heard a case, and it was a phenomenal experience, life-changing, really. As a lawyer, it was so exciting to come and do this. I would have loved to have been doing this live, standing outside in front of the Supreme Court of Canada, but it is really, really cold here in Ottawa, and so I wasn't brave enough to stand out in front and do a live, so I'm at my hotel. But I want to, just say it has been an absolutely amazing experience, and I'm going to be taking it with me, into my law practice and handling of some of the cases I have where there are elements of domestic violence in them.
Lovely, lovely. Well, thank you for sharing your experience of the Supreme Court of Canada and the Ahluwalia case resulting in the right to seek compensation for family violence. We'll see you all next week. Thank you.
Thanks, everyone. See you next week.